We're joined now by an employment and labor law specialist, Osborne Molatudi. The CCMA recently overturned a ruling on mandatory vaccination for an employee, meaning that human resource management in various companies could have a conundrum on their hands. Let's speak to Mr. Molatudi for more on this. Thank you very much for availing yourself this afternoon. So the commissioner, in handing down this ruling, said this is a red line, and also noted that it's not the first concerning the same employer. So in this case study that we're looking at, what is it that we need to know in terms of what is different?
Indeed. Earlier on, I was just saying that the commissioner in this matter decided to depart from the norm. As we all know by now, that most awards have been in favor of employers in terms of situations where employees were refusing to be vaccinated. Some employees were dismissed for insubordination, others were retrenched. So this is the same matter where an employee was retrenched, and the commissioner in this case needed to consider whether or not the rule relating to the implementation of the mandatory vaccination policy was reasonable or not. And at the end of assessing all the evidence presented before him, the commissioner came to a determination that the rule by the employer was in fact unreasonable, because the employer is not there to legislate. It's for the government to do so. And that is why the award is in favor of the employee. So in other words, the retrenchment of the employee for refusing to be vaccinated was found to be substantively unfair, and that employee was awarded 12-month compensation. Now, from a labor law perspective, it's quite an interesting award, and one is certain that the employer will consider taking this award on review to the labor court.
What does this then mean? As you rightfully mentioned, there are people who lost their jobs because they refused to get vaccinated. Does this mean then that this will open the floodgates for those who lost their jobs to appeal?
Indeed. I think what this award demonstrates, and for the benefit of your viewers, is that each case has to be assessed on its own merits. So there was a similar case where an employee was retrenched, and that employee's retrenchment was found to be fair. In this one, the commissioner came to a different determination. So that's the person that your viewers and many others have to bear in mind, that it's not necessarily that this award will set a precedent for similar cases, and more so because commissioners are not bound by the awards of their fellow colleagues. So an award is not a precedent, but if it's a judgment, then it can be a precedent. So what will happen is that employees will continue to exercise their rights and challenge their dismissal and take them to the CCMA. Obviously, most of them will hope that some commissioners will come to their assistance.
What does that mean then for the employer? As you rightfully mentioned, the commissioner saying an employer has no right to formulate any COVID-19 vaccination mandate.
It certainly means that they'll have to obtain more clarity from the higher courts, such as the labor court or the high court. And the reason why I say this, and bear with me because I've been repeating this point many a time, is because there is a law called the Occupational Health and Safety Act that requires employers to maintain a safe workplace. And one of the ways to do that, it may be that the employer may decide to introduce a mandatory vaccination policy after conducting a risk assessment plan with the consulting employees, trade unions, in it. So I'm most certain that the employer would want more clarity from the labor court and take this award on review. And the reason being that there is a law that obliges the employer. By the way, the employees also have an obligation to assist employers in minimizing any risk in the workplace, and more so because COVID-19 has been identified as a health hazard, and therefore employers feel that they have the obligation to do something about it.
Let's expand on that point, be it the CCMA or the courts. What bearing especially does the recent relaxation of the rules, especially when it comes to not wearing of masks, etc., even though people are still encouraged to get vaccinated, many would then assume, well, why should I? We are now here. So what bearing will this have?
It's a confusing one, if I I may put it bluntly that way, because you have one law passed by one minister repealing the wearing of masks in the public, banning or repealing regulations that ban groupings and foreigners entering our country. Then we have another minister passing a code of good practice just recently on the 24th of June, where employers still are permitted to regulate, COVID-19 in the workplace. So it's going to be very confusing. Labor lawyers are going to be busy, no doubt, and it is what it is. But what is encouraging that employees and employers will be able to make use of that opportunity to exercise their rights in terms of our constitution if they're not happy with certain decisions there. But yeah, it's going to be confusing going forward.
Employment and Labour Law Specialist Osborne Molatudi. Thank you.